Welcome. In this video, we will explain what typically happens at your first court hearing after filing for divorce and how to prepare for it. The first court date is called an initial hearing. The purpose of the initial hearing is to make sure that your spouse was served so that both of you can participate in the case. This is a chance for the judge to meet both of you and find out what things you and your spouse agree on and what things you do not agree on. At the initial hearing, the judge will ask you and your spouse questions based on the forms you filed. For example, the judge might need to decide if the case should be heard in D.C. This means that the judge will decide if D.C. has jurisdiction to hear the case. The court may also ask when you were married and if everything you said in the filed court papers is still true. If there are issues that you do not agree on, the court will send you to the court's attorney negotiator or the court's free mediation program, which is called multi-door mediation. If there are issues involving custody, the court will order you and your spouse to attend a one-time class called the Program for Agreement and Cooperation in Contested Custody Cases, or PAC. If you have a civil protection order against your spouse or you are afraid of your spouse, you should inform the judge and the facilitators of each program so they can best accommodate you. Additionally, if you and your spouse do not agree on issues, the court will schedule another hearing after mediation to check in about how the case is going. This is called a status hearing. While the case is pending, there may be issues you need the court to decide for you. For example, you can ask the court to have your spouse pay alimony, spousal support, or decide who can stay in your shared home or pay which household bills while your case is pending. If you have children together with your spouse, you can ask for temporary child custody and child support. If so, you can ask for a temporary order that addresses these issues while the case is pending. Be ready to ask for these things at the hearing. If you are asking for alimony or child support, make sure you bring proof of your income to the hearing. If you want to find out how much money your spouse may be asked to pay in child support, you can check out our video called How to Use the DC Child Support Calculator. If you are requesting temporary alimony, exclusive use of the marital home, child custody, or child support while the case is ongoing, you can file your request along with your complaint for divorce. You can find the motion for temporary relief and the motion for temporary alimony at the DC Bar Pro Bono Center's website for pro se forms. This link, along with being on the screen, can also be found directly below in the video description. You can also raise these issues orally at the initial hearing. If you and your spouse agree on all issues related to your divorce, the judge may ask if you want to proceed with the divorce hearing that same day. In that situation, the judge will ask you and your spouse a list of questions such as your name and address, how long you have lived in D.C., when you were married, where you were married, whether there is any chance of reconciliation, meaning whether there is a chance you might get back together with your spouse, if you have children, if you want to change your name, whether there is marital property and debt to divide, and, if so, whether you agree about how to divide marital property and debt. If you and your spouse have children together, the judge will ask if both of you believe the custody arrangement is in the best interest of the children. Also, the judge may ask whether you have been convicted of a crime, and if so, the date of the conviction and whether the crime was related to abuse or neglect of a minor child. The judge will likely require you to provide a copy of your marriage certificate or to testify about the date and location of the marriage. Regardless of whether you and your spouse agree about all the issues related to the divorce, you will be required to come to the first hearing. If you agree on all of the issues, then the judge will give you the divorce order immediately after the hearing or send it to you via mail or email. Your divorce won't be final until 30 days after the date that the court issues on the divorce order. However, the court may ask you and your spouse if you want to waive the right to appeal. If so, you both give up the right to appeal the ruling, and the divorce becomes final immediately. Please note that the Family Court Self-Help Center can help you complete the forms you need to file with the court. The Family Court Self-Help Center does not provide any legal advice. It is located in Room JM 570 of DC Superior Court. If you need referrals for free legal advice, the Family Court Self-Help Center can provide a list. Please feel free to revisit this video and the rest of the videos in the series whenever you need help. Thanks for watching.